2019, we shared more than 2,600 referrals among our member firms. Our members are deeply established and respected firms in their markets with in-depth knowledge of the local business community, customs, and culture. For more information on World Law Group, you can always visit our website. With that, I will now hand it over to our moderator and to the co-chair of World Law Group's Human Resources Law Group, Sugandhi Singham.
Thank you, Hannah. Good morning, good afternoon, good evening to all of those who joined us today. My name is Sugandhi Singham, and I'm from the firm of Shern Delamore and Company in Malaysia, your moderator. Joining us today, we have a distinguished panel comprising of Christoph Hui from Russia, Gabriel Lima from Brazil, Nancy Perkins from Washington, and Rosemary from the Philippines, who will share their thoughts during our discussion on the privacy and data protection issues which will arise within the COVID-19 environment. It gives me great pleasure to introduce you to our panelists today. Christoph is with CMS Russia and is a French lawyer registered with the Russian Ministry of Justice as an official foreign legal practitioner in Russia. He's a partner in the commercial practice of CMS Russia for almost 15 years, specialized in employment and immigration law. He also heads the CMS Russia COVID-19 task force. Gabriela is a partner of Tozini Freire Advogados, a law firm in Brazil, specializing in the labor and employment area. She specializes in preventive legal advice, assisting clients with local and cross-border labor and employment matters. Nancy is counsel at Arnold & Potter, LLP in Washington, D.C., and advises clients on a wide range of privacy and security matters at the federal and state levels, as well as on cross-border data protection issues. She has particular expertise with the privacy, security, and breach notification regulations, implementing HIPAA and the HITCH Act, and has worked with clients on compliance policies and procedures. She has been recognized by Chambers USA and Chambers Global for privacy and data security, and is serving as an advisor for the American Law Institute's current project, Principles of the Law Data Privacy. Last but not least, we have Rose, who is a senior partner at CSIP Salazar Hernandez Gatmaitan and helps lead the firm's TMT and data privacy practice. Her work in data privacy work ranges from helping companies comply with basic requirements to dealing with data security breaches, and she actually started advising clients well before the Philippines enacted the data privacy statute in 2012. Her clients in this practice include IT and fintech companies, media enterprises, BPOs, and professional service firms. As part of the return to work policy, most organizations have implemented safety measures and protocols in place. This brings about questions as regards the mandatory measures that can be imposed by companies whilst balancing the right to privacy in respect of the information obtained. The first question we have for our panelists today: mandatory COVID-19 testing. Can employees be compelled to undertake the same, as well as temperature testing? Gabriela, could we hear from you? What is the situation like in Brazil?
Hi, thank you, Sugandhi, for this introduction, and thank you all for being here with us today. It's a pleasure to be here with my colleagues to discuss this topic that is such a hot topic for in our area today. So I know we have a very few time to address all questions we have been receiving. So I'm going to go directly to the question, to this question. So here in Brazil, employers have the duty to preserve the employee's right to perform and develop their activities in a healthy and safe work environment. But medical information is a sensitive personal data and pertains to the employee. So at this point, I think so we all at the same page. I think it's nice to mention that here in Brazil, we have a pretty recent data privacy law. Our law was published in August 2018, but just became effective this past September. But even before the law, we already had privacy rights established in our constitution. So that being said, and going back to the question, we do not have a specific law related to both type of testings, but we do have a ordinance, like an order or guidance, guidelines from our labor and health authorities together, which establish procedures for mitigating risks related to COVID-19 when going back to work. So yes, companies may determine mandatory temperature testing. It is a measure that will protect everyone, and it's even recommended by our authorities. But when doing that, the company has to be careful to avoid any discriminatory treatment, must provide the employees with the data that they are collecting, should delete the information as soon as it becomes irrelevant, and should also have a protocol related to the measures that will be taken if the employee has a high temperature. But on the other hand, when we go to COVID-19 testing, this cannot be mandatory. This ordinance that I just mentioned about our health and labor authorities together, it states that COVID-19 tests should not be a condition for resuming activities, because up to now, there is no technical recommendation for this procedure. In other words, COVID-19 testing may be performed only on a voluntary basis. This is the safest approach currently here in Brazil related to data protection and employment matters. So, but if the company implements a voluntary COVID-19 testing, the test should be performed by authorized personnel like health professionals, should follow the guidelines of our health authorities. The employees should authorize the companies to have access to the results. The company should only allow the personnel, the internal personnel, the ones that really have necessity to have access to the information, to have this access of the information. And the company should avoid any discriminatory treatment, delete or anonymize the information as soon as it becomes irrelevant. And also when implementing this voluntary COVID-19 testing policy, the company should think about other operational factors like frequency of the testing, no immediate results, the costs involved, and among others. So just resuming everything, temperature testing is very common and everyone is doing COVID-19 testing only on a voluntary basis.
Thank you very much. And I guess in most countries, that is the situation. If one exhibits symptoms, then that would be a basis, but otherwise you cannot compel employees to undertake such tests. This then brings us to the issue, what about the right to privacy and the information obtained? What about the requirement by employers to have questionnaires or certifications from employees asking about if they are from the risk group, symptoms, COVID-19 diagnosis, recent travels, and compliance with social distance? What about that situation? What's the situation like in Philippines, Rosemary?
Yes, thank you, Suganthi, and good evening to everybody, or good morning, depending on where you are in the world. Maybe I can start my response by noting that even in this health crisis here in the Philippines, individuals and certainly employees continue to enjoy a right to privacy under our data privacy law. Of course, employers can and in fact must obtain certain personal data from employees in order for them to comply with their obligations. And I'm talking about an obligation to keep the workplace safe. So this is something that Gabriela also noted a while ago, an obligation to undertake certain notifications that are meant to prevent the spread of a communicable disease. So these are the obligations for which an employer needs to gather particular personal data from employees. And this is not, I think, at all at odds with an employee's right to privacy. Now, the Philippine government has released a lot of issuances, quite a number actually. And under the guidelines, employers are actually required to have their employees complete a health declaration form. And I'm sure in other jurisdictions, you will find something like that too. So in our guidelines, you've got this health declaration form. It sets out a list of questions that the employee must answer. And what are these questions? Employees are asked to advise whether or not they have particular symptoms that are associated, of course, with the virus. Fever, a cold, sore throat, aches and pains. Employees are also required to answer questions about recent travel. So in the past 14 days, have you gone outside the Philippines? Have you gone outside of Metro Manila? If so, if yes, where did you go? This form will also ask you and can ask you if you have been in contact, close contact with a person who is either diagnosed with COVID-19 or is or is suspected to have the virus. But those essentially are the types of questions and the types of information that an employer must obtain from the employee and an employee must provide. So I guess the question, and this is something that I'm sure everybody on the panel, they always receive a question like this. Can I ask this? Can I ask that? For example, can I ask information that will tell me if an employee is in an at-risk group, right? And in the Philippines, an at-risk group is somebody who is 60 years old and above, a senior citizen, somebody who is pregnant, and of course, people with comorbidities, right? So serious illnesses. So can the employer ask that from an employee? The simple answer is an employer can, but you may not be able, generally you cannot compel the employee to answer, to provide a response in general. Of course, if the situation were different, for example, if the employee said, I need to work from home because I am in an at-risk group, of course, the employer can now ask more questions from the employee about that condition and what it is. Is it a comorbidity, etc. So are there other information that an employer can ask? Again, you've got this guideline that sets out a particular set of questions you must ask. Beyond that, an employer will have to look at the basic principles of our Data Privacy Act to see whether it is something that they indeed could have a basis for asking.
Thank you very much, Rosemary. This then brings about the issue: what are the consequences for employees that refuse to provide information in respect of the test, or they refuse to return to face-to-face work? Christoph, could we hear from you? What is the situation like?
Yes, hello everybody, and thank you for being with us. So first of all, I'd like to mention that, as you know, Russia is a federation and there are 85 subjects of the Russian Federation. And from the very beginning of the pandemic, powers have been given to each governor to set and to implement some specific rules depending on the local spread of the pandemic. So since, according to the time frame which is granted to us, it would be impossible to consider the 85 particular legislation, I will focus on what is done in Moscow. So here I would distinguish the three items: information, testing and temperature, and return to face work. First of all, with regard to information, according to a decree of the Moscow-Meyer, which was passed in May this year, employers have to inform their employees of any chronic disease, pregnancy for the women, as well as respiratory disease. And if the employee does not do it, he can be, as an individual, subject to administrative liability or even criminal liability, depending on the consequences of the fact that he did not disclose this information. If it is connected to, for example, to mass infection, or to even, unfortunately, the death of one or two people. So this is as an individual. As an employee, if the employer has set in its local normative act the same obligation, and if the employee does not disclose the information he is due to disclose, he can be as well, from a labor point of view, disciplined, from warning, reprimand, up to termination of his employment agreement. With regard to testing and temperature, so as in many other countries, so employers has to measure body temperature for employees coming to the office for each 4 hours, and 10% of the employee present in the office must be tested each 2 weeks. So if one employee refuses to have his body temperature taken, the employer is entitled to, should refuse him to enter the premises, and he has to go back home. And if such obligation, or if in the local normative act as well, it is provided that he has his temperature taken each 4 hours, and if he doesn't want to do it, disciplinary sanction can be taken, at least a warning, request for explanation, and depending on the answer, at least a warning. With regard to COVID test, this is a more difficult subject and matter, and because we cannot push or compel someone to have this test done. So if an employee who is supposed to be in the office and doesn't want to have this test done, what employers do is that actually the day where the tests are done, because they are done by a specific accredited laboratory, the employee does not show up in the office, because we cannot force someone. With the last item, return to face work. So actually, this is not really, as in many countries, up-to-date issue, because recently the mayor of Moscow has passed another decree according to which at least 30% of employees must be sent to remote work. So, but the same, and the notion of temporary remote work does not exist as such so far in the Russian legislation. So there is a bill which is actually discussed in front of the State Duma. It has passed the first reading. Second reading is not to take place yet, because obviously there are a lot of issues about which the deputies cannot agree. So we are informed that the second reading may not take place very soon of this draft law. But so when in March, when employers have been asked to send, or have been required to send people in remote work, it has been made by employers, if I can say so, in an empirical way, meaning that in the absence of any legal information on the remote work as such. So some people did through amendments to the employment agreement. Some employers did it through internal order. So until we received some recommendation from the Ministry of Labor, who agreed that sending people on remote work through local order is enough. But most of employers have done it through amendment to or addendum to the current employment agreement. In this addendum, or in the order, there is a date which has been set according to which the employer is supposed to come back to the office. If he doesn't want to come back, and unless he has a legitimate excuse, for example, he has COVID-19, or some of his close relative with whom he's living has such a sickness, So if he doesn't show up on the day he's supposed to, it can be considered as absenteeism, and therefore, once again, the employee can be disciplined for a labor point of view. So we have, in summary, administrative and criminal liabilities for not providing information on own state of health for some specific disease, including COVID-19, and the rest, if all obligations the employee has to fulfill are mentioned in internal normative act, it can be discipline, warning, reprimand, up to termination of employment agreement.
Thank you very much. And is the situation the same in Brazil, Gabriela?
So more or less. So we don't have here like criminal and administrative liabilities for the employee or for the employer related to the providing of information and COVID-19 testing. I apologize, sorry. Sorry. So, but we do have pretty similar situations, like Rosemary said, related to the information. So the employer can ask information about a risk group, but if the employee does not provide, the employee does not provide, but most of the employees currently, they do provide because they do understand that it is for the a greater benefit, for a collective benefit, and for the company to have a better policy from return to work. But yes, if someone refuses to reply, the company will only have asked and the employee will be refusing to provide this personal information. And related to the temperature testing, which is recommendable and even mandatory, if the employee refuses to do it, then he may have some disciplinary actions, measures taken by the company, like he has to be sent home and he may lose that day, will not be paid for that day. Related to the COVID-19 testing, as I said before, since it's not mandatory, it's very unlikely to be able to enforce and to apply any disciplinary measure related to that. But we do have some positions that would require to do that, like an employee with symptoms. So then we would be able to have a better argument if the company wanted to enforce that. But it's more or less like what Christopher said and Rosemary said, but we related to returning face-to-face work. If the company is allowed to return face-to-face work, and here in Brazil now, we like all types of activities are already allowed to go back to work because we had some phases and now we are allowed to go back to work. Each company is entitled to have your own policy, like rotation schemes and sanitary measures. But if the company is allowed to go back to face-to-face work and requires the employee to go back to face-to-face work, the employee cannot refuse unless he has a very serious justification. So then in this case, the employee should tell the company what is the justification. The company will address it and will decide if any disciplinary measure will or not be applicable. Like if the employee just says, no, I prefer continue to working from home, then the company can say, I'm so sorry, but I need you back to the law. I need you back to the office. So, and then if the employee is absent, then you can apply warnings, you can apply suspension, and in a worst case scenario, you can even perform a termination with cause. But if the employee explains to you what is the reason he doesn't want to go back to face-to-face work, I think companies should take this on a case-by-case basis, because not only if the employee is sick, but maybe the employee has someone at risk group, at his family, and if the company can accommodate, this would be a very good human resource practice. Sometimes the company cannot accommodate and still may demand the employee to go back to work. And that's why I think, and our recommendation is in this case, to take on a case-by-case basis when the employee refuses to go back to work.
That's very sound and practical advice that I would also echo. Thank you, Gabriella. So interestingly enough, once you have positive testing, then this then brings the issue. What are the obligations to maintain that confidentiality of information when you have a positive test, or even if you suspect your employee of contracting COVID? What are the obligations then? Nancy, could we please hear from you? You're on mute, Nancy. Thank you.
Sorry. Thank you very much. In the United States, as many of you may know, there isn't an overarching privacy law that would apply in this situation. And the laws that do apply in the employment context are really employment laws and really are not focused primarily on privacy. However, they do have provisions that are applicable in this situation, and they're interesting in terms of having a sort of a balancing, which I think is a lot of what we're talking about, between interests. But the basic rule is that you do need to maintain the confidentiality of any medical information. Now, whether information that you're suspected of contracting COVID would rise to being medical information would depend on the circumstances in terms of what that suspecting would come from. But there is a requirement to maintain confidentiality. At the same time, there are requirements now from the Centers for Disease Control and others for reporting of positive testing, and employers certainly are obligated to comply with those laws. And so to the extent that they have those obligations, the confidentiality provisions would not apply. As to what they say in the workplace, and I think we're going to others in the workplace, I think we're going to discuss this a little more. There should be no disclosing of an individual's identity, either with respect to having contracted or being suspected of contracting. To the extent possible, there should be no mention or suggestion of the individual's identity. Then we get into the questions of what they need to do to protect others in the workplace. And I think that's going to kind of come in our next questions.
Thank you, Nancy. And Rosemary, what about the situation in Philippines? Is it similar?
As I mentioned earlier, the individuals continue to have the right to privacy, of course, including, of course, individuals who have the virus or are suspected of having the virus. Our laws allow the disclosure of information relating to the infection, but only insofar as this is necessary, of course, in the interest of public health and public safety. So how does that work? Because even if you do have this, and Nancy was mentioning this, you still have all of these confidentiality obligations. They don't fall away. How do they work? First, you can disclose, but you cannot disclose to just anyone. Within the organization, the employer must only have particular staff dealing with it, dealing with the health declarations, for example. They cannot spread all of the information to the other employees in the organization. When it goes out to only specific entities or persons, the Department of Health, specific officers in the local government unit, and of course, the hospital or clinic where the employee might be referred to. While the employer has the information, it has to be kept secure. It can only be used for those specific purposes. And when it is no longer necessary to keep it, then it must be disposed. So how you deal with that data, the restrictions are really the continuing confidentiality obligations imposed on COVID-19 related data.
Yeah, and I'll just add to that, under the Americans with Disabilities Act in the United States, medical information on an employee must be kept separate from their personnel file. So that sounds somewhat similar in terms of use, because it's one of the main, well, really the main purpose of the Americans with Disabilities Act is not to discriminate on the basis of a disability, and COVID-19 would be a disability, at least positive testing.
Thank you both. And Christoph, could we hear from you in the situation in Russia, please?
Yeah, so in Russia, actually, there is a discrepancy between the COVID-19 legislation and what is done in practice. So as in many other countries, any health-related data are sensitive data and therefore must be kept confidential. According to the COVID-19 related legislation, if the employer suspects one of the employees to be sick or has the information that an employee is unfortunately sick, first of all, he has to immediately send him home and advise him to call a doctor. The doctor will decide upon the result of the first examination if a test is needed or not. If a test is needed, a specific laboratory will visit the employee, run the test, and if the test appears to be positive, he will inform what is called Rospotrebnadzor, which is the federal service on surveillance for consumer protection rights and human well-being, sorry. But I will call it Rospotrebnadzor. And then Rospotrebnadzor, who has this information on the potential infection of an employee, will contact the employer, request the employer to identify the contact person, and Rospotrebnadzor will contact itself each employee eventually concerned. This is in the law. This is how it should apply. In practice, and we had the case in our offices where unfortunately one of our colleagues got COVID-19, we are still waiting 2 months later a call from Rospotrebnadzor to identify the contact person. So, and this is for us, but it applied as well to many other clients. So what is done, and it, as it was mentioned as well by Nancy, is that actually the employer and us, we took upon ourselves to inform on an unnamed basis and individually each person who has been in contact or may have been in contact, and we send them home in self-isolation for 2 weeks. So normally, employers are not concerned by the confidentiality because everything should be dealt by this federal service. But in practice, we had to deal with this because unfortunately, the Rospotrebnadzor is failing to do what it should be doing. And so this is why, and this is shared by the legal community here, that employer inform the colleague, but on an unnamed basis, and of course it is only the head of HR department who should be doing it, or a person specifically appointed. So this is the way employers currently are compensating, if I can say so, the defect or the inaction from time to time of this specific federal service. And in order to protect its employees and keep information confidential. Thank you.
Thank you, Christoph. And that interestingly brings about the question. Now, what about the obligation then to inform work colleagues who actually come into contact with the individual? They have a right to have such information made available to them. Nancy, what are your thoughts on this?
I would say as a general matter, yes, they do. The question is, from a privacy perspective, do they have a right to know who has tested positive? And that's going to be tricky in terms of, can you prevent a disclosure that someone has tested positive from being at the same time a disclosure as to who has tested positive? And it will depend on the workplace, but it is a greater obligation to inform other employees that they may have been exposed, and without revealing a name, discussing, for example, when they may have been in contact with someone, where they may have been in contact with someone, how close their contact may have been so that those other employees can take precautionary measures. Now, if the other employees can infer, because they were only with one other person on that date or in that place, then that's going to be okay. It's a necessary kind of corollary with the need to let other employees know. This is really an obligation of public health and safety that overcomes the rest. And so the other employees need to be able to do whatever they need to do, either get a voluntary test or quarantine, according to if they're, for example, high risk. So yes, that they do know.
It's a fine balance, I think, and I would think that most would want to know who they've come into contact with. And Gabriella, would you take that same view as well?
Yes, it's pretty similar to what Nancy said and what you said related to the balance, but here the greater is the public health. So, and even in our guidelines, that which is not a law, but it's a guideline, the authorities, they recommend the employer to inform the colleagues that have had a contact with someone that had COVID-19. And even in our guidelines, what it's mentioned is that for the colleagues that have had contact, colleagues should also be sent home for at least 14 days for the quarantine period, and in order to protect spreading the virus. They should return to work prior to these 14 days if they do not feel bad, if they take a COVID-19 test and is negative, and if they don't feel any symptoms in 72 hours. So like, if it is possible to not say the name of the employee, but like Nancy said, like if you only work with 2 co-workers, and then it's like, that's okay to say who had the COVID-19, but you do not, like as an employer, you should not tell everyone from the company, but only the colleagues that actually need to take some precautionary measures.
And I'd like to add too, which is the role of the role and the will of the person who has tested positive. What we've found is that often it depends somewhat on the workplace, but this is a global pandemic and everybody recognizes that. And I think people really do want to help others in this situation and recognize that if they've tested positive, they themselves should be letting, not only workplace members know, but friends and others who they may have come into contact with. And one thing that an employer can do, I think, to sort of foster an entire workforce approach is to speak with the person who's contracted the virus and say, would you like to voluntarily tell others? Would you like to be the one who tells others as opposed to us, so that it's a more straightforward and open thing from you, and that you are making a gesture toward public health and safety yourself. Now, obviously, this depends on the person not being too ill to do that, but it is a way of addressing these privacy concerns that I think also can foster others in the workplace taking the same approach if they've had contact. It's sort of a, like we're in this together kind of situation.
That's a good suggestion, actually, a reversal of roles rather than the obligation being placed on the employer. Christoph, you have a live situation, you said, within your organization. Share with us.
Yeah, so as I mentioned, the employer has no such obligation according to the COVID-19 legislation because it is done by this federal service. So, but in practice, it doesn't always work. On the other hand, according to the provision of the labor code, the employer has to ensure a safe work environment to the employees, protecting them to any threat or from any health or safety threats, which, on the other hand, from the employee side, they have a legitimate right, yes, to receive such information from the employer. So here we have the fact that the employer is not does not have to inform, but on the other hand, according to COVID-19 legislation, as we call it here, and on the other hand, has the provision and to comply with the provision of the labor code, which says that it has to provide a safe environment to its employees. So in case we have, and as we did, and that was more or less what was mentioned by my colleagues, what we did once we identify the contact person, we, on an individual basis, we approach them. So meaning that we did not disclose the information to the whole office. We have a big office, so it was in the, let's say, in the left-hand side. So the left-hand side people were contacted on an individual basis, and we did not disclose the name. We just say that the case happened, and this is the same in for many clients. We had a case, so please go home, stay at home within 2 weeks. We advise you to have a test. Of course, we cannot force them, but at least you stay at home. And if some symptoms appear, please call a doctor.
Thank you, Christophe. So the question then becomes, how do you balance this right to maintain confidentiality of data in respect of the person who has contracted COVID, and at the same time needing to balance between privacy rights, employer rights, and public safety rights? Rosemary, could you share your thoughts with us, please?
Yes, sure. Well, for the Philippines, I think an employer here, at least initially, would have a straightforward approach available, and that's really to adopt and follow the guidelines that have been issued by the agencies. And as I mentioned a while ago, they have been very industrious in in releasing these guidelines, but they can be helpful because if the employer follows them, then effectively they're able to comply with what government thinks would be the minimum necessary, right? And this is the phrase that the privacy regulator always says. Our privacy regulator, he will always say, collect, process the data, do with it only up to the minimum necessary. Now, certainly, not all situations can be covered by these guidelines or these issuances, the various things that the panel has been talking about. I mean, there will certainly be something that falls outside that scope, right? And here, there's really nothing to do but to rely on the principles of the Data Privacy Act in the Philippines. If you have a situation, you've got this information, what are you going to do with it? You have to ask yourself, do you have a lawful basis? If it's not something that is covered by a legal obligation, and it's likely it's sensitive personal information, right? Then you'll have to get consent of the data subject. It can only be processed for specific purposes, and it can only be shared or used in particular ways. So at the end of the day, that's really what will be the guiding principles for an employer in trying to seek that balance among these competing interests.
Thank you. And Nancy, you mentioned earlier that you would be touching base on this as well. Could we hear from you?
Yeah, I mean, I think this question is really, it's almost more a regulator's question in that this is the big public policy question for the law and public policy. And basically sort of, it seems to me that employers, and I think this is kind of in line with what Rosemary is saying, they need to follow what the greater good has been determined by those who are making policy and making law, and work within that. I do think, though, when it comes to privacy, that that it's kind of in line with what I suggested before about, talking to the affected individual, that one approach to this that can be helpful, and it's gets very difficult if you're in a situation where an employee is very dependent upon their job and you've got to enforce some regulations that are going to have an impact on their economic situation, et cetera. But the more you can foster an understanding that a group effort is needed in order to address this pandemic, the easier it is to deal with the balancing, because each individual has a sense that their rights are connected to others, and that they need to think in the whole, kind of, in terms of not just my privacy in this situation. Yes, I need to protect others by, informing them about myself, or quarantining as I need to, et cetera. And I think that an employer has the ability to foster that. I think that the regulators are the ones that need to make the big policy decisions about, what is actually legal and isn't. But I think that's where an employer has some flexibility.
Thank you, Nancy. This then, of course, brings us to the issue of contact tracing. What types of contact tracing methods are appropriate, and can you actually compel employees to use a contact tracing mobile application? Gabriela, could we hear what the situation is like in Brazil?
Sure. To tell you the truth, this is a question that we have been receiving, but the first time I received it, I was like, oh my God, now it's an additional thing that people want to do it, like contact tracing. I was actually surprised at the first time I received the question, and then I noticed several clients asking the same. So pretty common, maybe must be common more in places where COVID-19 have already started before Brazil was reached to. But the response, we don't have a guideline related to this, different from COVID-19 testing and different from temperature testing. We don't have even a guideline related to that. So then we go to the balance of private information and employers' duty to preserve the work environment. And we go to our data privacy law. So yes, during the working hours, the employer can implement and can demand the employee to use a contact tracing method, and then any method that is able to trace that would be okay to do it, but only during the working hours. And the employers should inform the employees what type of information would be collected and what would be the use for that, and who have access to this information. Should be very small group of persons or of people to have access to the information, and treat it as confidential as much as possible. And after working hours, then employers cannot demand the use of contact tracing methods. So in this case, it would be only on a consent basis, on a voluntary basis, if the employer wants to implement that.
Thank you, Gabriela. And Nancy, I know this is a subject close to your heart. You've been working quite extensively on this. Can we hear your thoughts on this issue?
Yes, I think it's actually a fascinating issue and is being approached differently in across the world. It's very interesting to see what different jurisdictions are doing and with different technologies. As far as the law goes in the United States right now, there have been 4 bills introduced in Congress to address contact tracing apps specifically. None of them have advanced so far, but I think there's a possibility that one of them may, in light of funding for contact tracing that is going, there have been some, as you may know, there have been major funding related to COVID-19 from the federal government, and some of it has been for contact tracing. And some states have put out, and in fact, I'm in the District of Columbia, and about a week ago, without any warning, my phone said, here's an app for you. Do you accept? And they actually didn't have much of a privacy notice, but I did, because I understand, I have done a lot of work on this, and I think it's an important thing. And this one is clearly only about proximity. So this is one thing for people to understand, is there are different approaches to what actually is collected through these apps. And one approach is just proximity, which is every person who is using an app, and it only works so far as others participate, your phone, to the extent it gets close to someone else's phone who has the app, will record that in a database. And over time, you will have, record of proximity to a number of people. To the extent that someone else who is using the app reports that they have tested positive, you will be informed that you have been in close proximity, and it will only be people who you've been in proximity to for a certain duration of time that you're at that much risk. But the value of that is that you get a notice. It's not disclosed to others. It is not blasted out. The thing about these is, and I know we're getting close on time and we want to allow for some questions, so I'm going to kind of hurry up. But I think the approach to these is that my own personal view, I'm not speaking for my firm, I'm not speaking for anybody else, but these things only work if a lot of people participate. Because if you're not getting, if people, for example, even in the workplace, someone could just leave their phone, hide it somewhere and not use it. So it's going to make no difference there has to be compliance here. So you have to get buy-in. And I think to get buy-in, you need to do kind of what Gabrielle was saying. You need to tell people what's happening here, what's going to be done with their data, and have the purpose of the data be others' health and safety, and have that understood to a point where people really do want to buy in. And one of the ways to do it is to not do it with what some of these apps do, which is geolocation, which is where are you going? And that's a very different thing from proximity. It's someone's tracking you essentially and seeing where you're going. So the proximity ones, to the extent people are using them, seems to me a very reasonable approach. And in the United States, to maybe go to your more legal question, some employers have started using them. Not widespread. I think that a lot of employers are nervous about the privacy implications and possible backlash, but some have. And some of it depends on, there are differences in terms of what information the employer gets and how they can access it through the app. Some are managed by third parties. I know that PwC created an app and they would actually house the data. And then there's a question of whether the employee name gets put in, whether you need the names to make this effective. So there are a whole variety of issues. And I do think, this pandemic is not ceasing by any means. And we really need to think about this. Contact tracing, setting aside technologies, has gone on for years and years. I mean, infectious diseases, people have been asked by their physicians when they are told that they've, got a positive test for whatever, who were you in touch with? We need to get in touch with them. So it's not a new thing, but we need to think, proactively on every tool we can possibly use. Now that the past 6 months have shown that we can't combat this pandemic by being passive.
Thank you, Nancy. And we've got two questions actually from the audience. Since you've just touched on contact tracing, I will cover the second question first, which is for contact tracing and the use of the app. If it's after office hours, can this be imposed upon employees? Can they be subject to disciplinary action for their refusal to comply? Could I please hear your views on this, Gabriella?
Well, so what I mentioned before is that after working hours, it's pretty hard to enforce a contact tracing method. So no, it would be, they would not be subject to disciplinary measures. But I do agree with what everything Nancy said, that like everyone should be aware of that and should like try to help to make better, like a better situation to stop this pandemic. But for legal purposes and considering what we have now here in Brazil and different from the US, we, as I said, we don't have any law at this moment related to contact tracing methods. So after working hours, without consent and no disciplinary measures.
So it doesn't extend to after working hours then. We also have another question. For purposes of a physical return to work, can the measures referred to in the form of the questionnaire or certification to complete be imposed on employees without their consent?
You're on mute, Sugan.
Sorry. For purposes of the physical return to work, can the measures referred to in the form of the questionnaire or certification to complete, can this be imposed on employees without their consent? Rosemary, could we hear your thoughts on this, please?
Well, in the Philippines, yes, it is required. And if you do not complete that questionnaire, you cannot enter the building. You will be refused entry into the workplace. And so, one of the questions earlier was, what's the consequence? Can you fire the employee? And when I was talking to my HR colleagues, they were saying, well, actually what would happen is the employee will be absent. And if he continues to refuse to fill up the form, he will continue to be absent. And if nothing else, he might be terminated for that reason.
Right. And Christoph, is the situation the same in Russia?
Well, we had actually the issues, for example, when because the borders of Russia are still closed, except with the hand of countries, but something like 12 countries. Otherwise, the borders are still closed. And but about holidays, for example, when people and where do people go on holidays? Can we request them to get information? If the position which is shared, because this is not touched upon by the current legislation, the position among the legal community is that if the fact that the employee has to provide some information, as the one which we talked about earlier today, are mentioned in a local normative act, we do, which must be countersigned against weight signature by the employee. We do believe that it is possible to ask the employee to comply with such obligation. If he does not do it, yeah, maybe you can warning or a reprimand, but especially considering the current state and the number of unemployment, we don't believe that the employer will have much over power, such as terminating the employment agreement should the employee does not comply with this. But the main point at the very, very beginning is, at least for at the employer level, to provide such obligation in the normative local act of the employer. Otherwise, there is no possibility for the employer to ask such information.
Thank you very much.
Thank you very much, Christoph. And with that, it brings us to the end of our session this morning or this evening for those of you who've joined us from different parts of the world. If I could just extend my appreciation to Rosemary, Nancy, Gabriella, and Christoph, and Hannah. Thank you for organizing this informative session, and have a productive day ahead. Thank you, everyone. Anna, I'll hand it back to you.
Thank you, Suganti, and a thank you to you too. You did not include yourself in that thank you. But yes, I echo Suganti's appreciation to all of our panelists. This webinar was part of, or is part of, a 3-week fall e-conference that World Law Group is hosting, and you can visit our website and the conference page to see what other sessions we have coming up and recording from sessions we've already had this week. The e-conference goes through November 12th. And with that, I hope everyone has a wonderful day or evening wherever it is you are. Thank you.
Thank you. Bye.
Bye-bye.
Bye-bye, everyone. Thank you.
Bye.
Bye.